Hello, everyone. I'm attorney Heather Ward with the Legacy Legal Team. I mainly focus my practice area on estate planning and some Medicaid and special needs planning. And today we're going to be talking about supplemental needs trusts, or special needs trusts is what they're more commonly referred to, which is a really critical area that we build into a lot of our estate plans, even if it's not necessary right now because you don't know somebody in your family that has a disability that would need this type of trust. But you never know what could happen. And there are a lot of people that do need this type of planning from the get-go. And so we'll kind of talk about the different reasons why that would be included and how to include it in your estate plan. Basically, special needs trusts are exactly what they sound like. It's a special type of trust that is used for a beneficiary that is, that definition is very broad, and we'll talk about how that's defined and who it applies to. But mainly, it's just to provide financial support to somebody who is entitled to needs-based government benefits. So like Medicaid, not Medicare, Medicaid, or SSI, which are needs-based, so you have to be quote-unquote poor enough to qualify for those. But the great thing about these trusts is that they're basically ignored for purposes of the government because it's not in their name. It's going to be used for extra things that the government doesn't pay for. So they're still entitled to those needs-based government benefits like Medicaid and SSI, supplemental Social Security income. But we can enhance quality of life with these extra. So that's really one of the main purposes of it, is to enhance quality of life. I mean, the government does a decent job paying for some things with these needs-based programs, but it's not always what you want, or I'm trying to think of a nice way to say it. It may not be the quality of what you want. So we can really enhance quality of life for these types of beneficiaries with these trusts. It supplement these government benefits, so it can't be used in ways that the government's supposed to be providing for, like housing, but it can be used for things like getting to a better bed, or your beneficiary a better bed, or a TV, or sending them on vacation, like things that the government is obviously never going to pay for. There's just really two broad types of supplemental needs trusts. I'm going to call them S&Ts from now on. It's just the shorthand version. But the first type is what's called a first-party S&T. These are kind of less common. They are self-settled, which means that it's somebody that is qualifying for these needs-based government benefits. They are able to set up their own trust that has to follow a special rule, but they can fund it with things like a personal injury settlement or an inheritance that they get. The reason why it's less common is because those things don't happen as often, but also the bad thing is if any money left over when that person dies has to be paid back to the state to cover what the state covered. So if you qualify for Medicaid, for example, and you have a supplemental needs trust that's all settled that you had $1 million in. If Medicaid paid $800,000 toward your care before you died, when you pass, that $800,000 has to be paid back, and then the $200,000 can be distributed however your trust says. So most people don't like that because we've got to pay money back, but it's still an option and can really enhance your quality of life. More often, when we deal with S&Ts, it's what's called a third-party S&T, which means it's set up by somebody else. Most commonly, it's through somebody's own revocable trust or their will, but occasionally we do have somebody that will set up a current special needs trust if it's somebody that they already know is qualifying for those types of benefits. That person that's setting it up, so say I have a nephew who is already disabled, is already receiving these benefits, and I want to set aside some money for him when I pass away. I then would direct that this money goes into this trust for his benefit. The great thing about if somebody else sets it up for the beneficiary is that there is no payback provision. That's not a requirement under the laws. So I put aside this money. If it's all spent, then okay, no harm, no foul. But if there's money left over when that beneficiary dies, I get to direct who that goes to, whether it's that person's children, whether it's another one of my beneficiaries, whether it's a charity, however I want that to go, I can say. It never has to go to the government. So again, most people do that through their own revocable living trust or through a testamentary trust that's set up in a will. But it doesn't have to be. It can be a currently set up one. And there's different reasons to do that, which of course you'll want to work with a experienced attorney on that to make sure, A, that the trust is done correctly, because there's tons of rules about what language has to be in there. But also to choose whether to go ahead and create that trust now or just set it up through your normal trust, quote unquote, for the future. There's a lot of rules about how these trusts need to be set up. If there's not specific language in the trust, whether it's set up through your own revocable trust or whether it's a current trust that you set up now, very specific language has to be in there. And if some of it's missing, it fails. And when it fails, your beneficiary that you've tried to set up is going to lose their government benefits, which can be a really, really, really big deal. I mean, somebody could be living in a skilled nursing facility, receiving government benefits to pay for that facility, and now they no longer qualify for that and have to figure out how to private pay until they are able to be eligible again. And becoming eligible for these programs is not an easy task. Like, there's a lot of applications, a lot of legwork done in the beginning to get qualified. So it's not really something people want to go through more than once if they're already there, or go through once for their family members. So without lots of very specific language, these trusts can fail. So again, very important to work with somebody that really knows what they're doing in this area. Excuse me. Those are set up by both federal and state laws. The other thing is that the beneficiary, in order for this trust to qualify, they have to meet certain requirements themselves, other than just the language of the trust. They have to be qualified for these benefits, which means they, like I said, usually have to be poor enough, quote unquote. Those numbers change every year, so depends on what that year's eligibility is. But they also typically have to meet the sick enough standards. So whether that is with Medicaid, they have to have certain, right, with disability, they have to be disabled to a certain point. With Medicaid, they have to be sick enough to where they cannot take care of themselves on their own. They have to have skilled level nursing, so they're not just like in an assisted living. So they have to meet the Medicaid and SSI work. Then they have to meet the trust requirements, and the trust itself has to meet the rules to be a qualified supplemental needs trust. Another really big thing that not a lot of people realize is that a supplemental needs trust that's set up for a spouse, so and my husband died and I needed to qualify for needs-based government benefit, his will, not his trust, his will actually has to say, okay, the funds that I'm leaving to my wife go into a supplemental needs trust. It's this weird, wonky rule that exists. He cannot set that up in his trust. It has to go through their will. It has to go through probate. And then the supplemental needs trust could be set up for me. I'm using the term supplemental and special needs back and forth. It's the same thing, but just we have kind of changed the narrative, just like a lot of things. Supplemental is more proper way to say it nowadays, but people still refer to it both ways. But yeah, so that's something not a lot of people realize, because it also seems kind of counterintuitive. Okay, I've got to set up a trust, but I have to set it up through my will. That it's interesting. For any other type of beneficiary, you can set it up through a revocable living trust. So really, the big benefit of these trusts, like I said, enhance quality of life for the beneficiary. We can do a lot of things like I mentioned before, sending them on vacations. Like, we've seen people where, they used to go to Disney every year. Well, we can still use this for that as long as they're still able to do it safely. We can pay for hobbies. We can help pay for a vehicle. We can do these other things that the government's not provide. So we are supplementing, not supplanting, those government benefits. And like I said, it's just really a peace of mind for people to know, okay, even if they're receiving government benefits, I want to make sure that they're happy, not just getting the bare minimum. So it's really a big peace of mind for people to know that they've prepared for somebody else's financial future, especially if it's somebody that otherwise wouldn't have it. I mean, if they're in a facility, they can't really go above and beyond what they're being provided for. I'm going to pause now to see if anybody here has any questions. But again, it's really just a very niche area of law, but a lot of people need it. Or I'm very big on planning for the what ifs. So a lot of the time, I will have some clients that I work with that say, Heather, there's no way this is ever going to apply to me or my family. Why would I put this in here? I can come back to you and amend this trust if it applies to somebody. Like if, God forbid, my child's in a car accident, or I think my husband is developing dementia, or whatever the question is. I am very big on planning for the what ifs, not trying to add it in later, because you never know if you're going to be able to add it in later. So let's just do it now. Oh, great question. Okay, so the question is, if I successfully set up an S&T and I pass, will someone make sure that my beneficiary is taken care of? Yes. So with a trust, there is always a trustee. So with this type of trust, if you're setting it up through your revocable living trust or your will, you can say, my normal trustee is the one that handles this special type of trust. Or you can actually say, my trust is going to be handled by my daughter, but the special needs trust is going to be handled by my niece because she actually knows about Medicaid or whatever the reasoning is. Sometimes people do choose a separate trustee for supplemental needs trust, which is a great thing. Another really great thing we can add in with a supplemental needs trust is what's called care manager provisions, because, the average person knows nothing about Medicaid or SSI. They don't know the rules. They don't know what will disqualify somebody. Because, if I'm using the supplemental needs trust funds to pay for something for this beneficiary, and it's not something I'm allowed to do, they lose their benefit. So it's really important for a lot of people to hire a care manager who knows those ins and outs, who can help, tell you what you can and can't use the money on, and also to tell you, okay, this is your beneficiary. These are the things that they struggle with. These are the things that will enhance their quality of life based on my professional experience. This is going to make such a difference. That's not something a normal person knows, or even the average trustee. Maybe my niece is named as the trustee for my brother. They may not have a closer relationship to know what my brother needs. So a care manager is somebody that can go in, talk with the beneficiary, and make sure that what we are doing is A, legal and valid for the trust, and B, is in the best interest of that beneficiary. Yeah, there are more questions pop. All right, it doesn't look like anything else is coming in. Today was a quick one. It's a busy week at the office. But again, I cannot stress how important it is if you, especially currently, have somebody in your life that you want to plan for who is already receiving these needs-based government benefits. I can't stress enough how important it is to go speak to an attorney that does this type of law. It's not just every type of estate planning attorney either. It's not a common thing to plan for. They're becoming more common. I think it's because the laws evolved a lot in the last several years, but it's really important to make sure that you're working with an attorney who knows the language that has to be included in order for Medicaid to even accept this kind of trust, or SSI to even accept this type of trust. Because if you don't, it's kind of all for naught, and nobody wants to spend their money happening. But yeah, I think that's going to be it for today. If anybody has any other questions, feel free to reach out to the office. We have a couple of attorneys in our office that handle this type of law. Or even if you just want to talk about your estate planning generally, you can reach out to us. And you're on our Facebook page, so you know how to get a hold of us anyways. You can send us a message through here or give us a call. And we'd be happy to get you going on some estate plan or special needs planning. Hope everyone has a good rest of their Thursday and a good weekend, and I hope to talk to some of you soon. Bye. Have a good day.